I think there are a lot of agencies in the federal government where it's hard to parse whether it's an executive function they're engaged in or a legislative function. We obviously have the Perlmutter case that they're holding where you're dealing with the Library of Congress, which half of it's a library, half of it's things like the copyright. What are we supposed to do with that, if you're correct? Yeah, I mean, I appreciate your point about not deciding cases that aren't before us, and I meant the Perlmutter case as an example. But I'm not sure you answered the question. Is this a severance issue? Do we say the agency is okay so long as half of it survives in one branch and half in the other? And if so, who gets to decide that? I think there are a lot of agencies in the federal government where it's hard to parse whether it's an executive function they're engaged in or a legislative function. We obviously have the Perlmutter case that they're holding where you're dealing with the Library of Congress, which half of it's a library, half of it's things like the copyright. What are we supposed to do with that, if you're correct?
Well, Mr. Chief Justice, in Free Enterprise Fund, this court, I think, very aptly stated that the vast and varied nature of the federal government is a reason not to make general pronouncements on issues that haven't been briefed and argued. There are certainly situations where there are tough line drawing problems. You raised the Perlmutter case as one that may raise arguments of that nature, but by and large, the sort of insight that goes from Morrison to FCC against Arlington and to Seal Law recognizes that these multi-member agencies that are exercising what this court has repeatedly recognized as quintessential executive powers, like the FTC, rulemaking, adjudication, investigation, seeking of civil enforcement power, litigation, seeking civil enforcement powers, or civil enforcement remedies, and so forth. Those are not close cases.
Yeah, I mean, I appreciate your point about not deciding cases that aren't before us, and I meant the Perlmutter case as an example. But I'm not sure you answered the question. Is this a severance issue? Do we say the agency is okay so long as half of it survives in one branch and half in the other? And if so, who gets to decide that?
For the vast majority of these agencies, I think Seal Law pointed out there's maybe about 24 executive agencies that are multi-member structure and have removal authority. I think the logic of this court adopted it for severability in Free Enterprise Fund and Seal Law, and Collins indicates that in the vast majority of cases there would be an excision just of the removal authority. Now, if there are agencies that kind of straddle the line between legislative and executive, that might present harder severability conferences.
Why is that severability the issue? Meaning, if you think they're wielding power that is inappropriate, why don't we sever that power?
I think those very arguments—
instead of the removal power.
Well, for example, consider an agency like the FTC, which is before the court. Virtually all of its powers, I can't think of a power that exercises this.
But most of those powers were part of Humphreys. This court, even in Sheila Law, and all of the cases you've mentioned since, have said that Humphreys is controlling law. You're asking us to overturn a case that has been around for nearly 100 years, correct?
90 years, I believe. 90
years. What other cases have we overturned that have had a pedigree of 100 years?
Pennoyer against Neff was overruled by Schaefer against Heitner on its 100th birthday.
That was an economic case. What other case?
For example, Erie overruled a Swifty Tyson 96 years later. Those are two examples. There's at least 13
but which other case has fundamentally altered the structure of government? For over 100 years, actually since 1887, we've had multi-member boards, and that's the entire government structure.
The distortion of the structure of government, respectfully, that philosophy of
aren't you asking us to distort it a different way?
I think we're
neither the king, nor Parliament, nor prime ministers, England at the time of the founding, ever had a unqualified removal power. You're asking us to say that at a time, the founding, when the Constitution doesn't speak about this at all, where there was robust debate over this issue among legal scholars at the time, that we ourselves has said repeatedly in Humphreys and other cases, Wiener, even in Myers, that that those cases you mentioned did not establish this absolute power of the president. You're asking us to destroy the structure of government and to take away from Congress its ability to protect its idea that the government is better structured with some agencies that are independent.
I think we're asking the court to return to the dominant line of authority that started in Ex parte Hennen in 1839, when this court said that it's a settled and well understood construction of the Constitution that the president alone can remove executive officials. That was reaffirmed in Parsons, for example, where it described it as settled beyond the power of alteration. Again, in Shurtleff, similar language. Myers says the same thing. Free Enterprise Fund, Collins, Seal of Law, Trump against the United States, and even Humphrey's executor itself paid lip service to this principle. Humphreys described this power as unrestricted and illimitable. And in order to get out of that rule, which the court has recognized in those 9 decisions, is going back to 1789.
You still haven't answered my question. Where else have we so fundamentally altered the structure of government?
I think what the fundamental alteration of the structure of the government was ushered in by Humphreys, and then the Congress kind of took Humphreys and ran with it in the building of the monstrous administrative state and the proliferation of independent agencies that are insulated from democratic
Independent agencies
control.
have been around since the founding, the Sinking Fund, the War Commission. We've had independent agencies throughout our history. So this is not a modern contrivance.
We disagree with that. As in our brief, we disagree with that characterization of those agencies. The Sinking Fund Commission, for example, was composed of 3 officers who were cabinet
And we have
secretaries.
an amicus that
clearly
shows
removable.
us how the president's will could have been thwarted by that structure. We have an amicus brief that shows us how that the president's will by that structure could have been thwarted.
These kinds of historical examples, I think, have been considered in this court's cases from Free Enterprise Fund and Seal of Law and so forth.
So what do we
There's been a
do
lively
with
debate
Morrison?
about that, and the court
What do
has
we do with Morrison and Wiener and Perkins?
Well, Morrison, for example, I think is a really critical precedent here, because what Morrison did is it repudiated the entire logic that supported the holding of Humphrey's executor. It repudiated correctly the idea that there are these quasi-judicial and quasi-legislative powers that are outside the executive power, and yet they're wandering around the executive branch.
Yet you
and not in-
answered Justice, the Chief Justice by saying that maybe we just need to look at each agency individually. So we can't leave that area. By the way, your logic, you're putting at risk. By this, you're saying there's uncertainty. I think the uncertainty in the lower courts was not over Humphrey's executor. It has been over the court's most recent decisions, not because of Humphrey's executor. But you're putting at risk the independence of the tax court, of the federal claims court, Article I courts. You're putting at risk the civil service. I don't see how your logic could be limited